President. I represent the report of the Legal and Constitutional Affairs References Committee on a public interest immunity claim, together with the Hansard record of proceedings and documents presented to the committee, and move that the report be printed.
The question is that motion be agreed to. Those of that opinion say aye. Those against say no. I think the ayes have it. Senator Wright.
Move that the Senate adopt the recommendations contained in the report.
The question is that motion be agreed to. Those of that opinion say aye. Those against say no. I think the ayes have it. The ayes have it. Senator Wright.
I move that the Senate take note of the report, and I seek leave to make some comments regarding the report.
Senator Wright, you've moved that. You have the right to speak if you wish to.
Thank you, Mr Deputy President.
Sorry, I beg your pardon. You needed leave to actually move the report, and then once leave's been granted, which I'm sure it will be, there's no objection to that. Now you can move that and then speak. Thanks, Senator Wright.
So I move that the Senate take note of the report.
Thank you, Senator Wright. You can continue if you wish to speak.
Thank you. I am very happy to table this report as Chair of the Legal and Constitutional Affairs References Committee. I rise to speak about this inquiry into a claim of public interest immunity raised over documents. This has been an important inquiry as it goes to the heart of the relationship between the Parliament and the Executive, and the capacity of the Parliament, in this case the Senate, to obtain information and documents about actions that are being taken by the Executive that are of concern to the very public which elects us to represent them here. I'd like to give some context to this particular issue, and to do so I'll go to the words of the Clerk of the Senate, Dr Lang, who was explaining to or giving evidence before the committee as to the background to a resolution of the Senate made on the 13th of May 2009 about a process that is to be followed when a claim of public interest immunity is contemplated. And Dr Lang pointed out that this is the important issue is the balance of competing public interest claims by government on one hand, that certain information should not be disclosed because disclosure would harm the public interest in some way, and by Parliament's claim, as a representative body in a democratic polity, to know particular things about government administration so that the Parliament can perform its proper function of scrutinising and ensuring accountability for expenditure and administration of government programs. This inquiry was referred to the committee by the Senate on the 10th of December 2013, and it followed the government's non-compliance with multiple orders from the Senate for the production of documents concerning on-water activities under Operation Sovereign Borders. In refusing to provide the information, the government raised a claim of public interest immunity. This is a claim which has been contested by the Australian Greens and also opposition senators. In this inquiry, the committee has sought to examine the grounds on which the government's claim of public interest immunity was based, as well as the Senate's authority to determine such claims. In this case, it is unfortunate that the committee has not been able to examine the merits of this claim of public interest immunity because of the government's unwillingness to provide further information. So the government has merely continued to assert the grounds upon which the claim is made, but has not identified any specifics about the documents over which the claim is made. And I'll go on to say the committee's ability to examine the merits of the claim has been frustrated because the committee was not provided with the relevant documents, nor the information contained therein, nor even a schedule listing the documents covered by the claim as explicitly requested from the Department of Immigration and Border Protection. The government was not forthcoming during the course of the inquiry with information in addition to that was already tabled in response to the orders for the production of documents, even on an in-camera basis or in altered form. The committee therefore had no ability to consider the validity of the claim that releasing such information would result in, quotes, possible damage to national security, defence or international relations, and possible prejudice to law enforcement or protection of public safety, which are the usual bases for such a public interest immunity claim. The government's unwillingness to engage in a meaningful way with this inquiry only serves to heighten the committee's suspicions and concerns about the information sought. As a result, the committee has recommended that the Senate consider a range of procedural and political remedies to resolve the current impasse. The committee has recommended that the Senate insist that Senator Cash should be required to explain what documents are covered by the claim of public interest immunity and how she reached the decision to make the claim. The committee reminds the executive of the Senate's right to information and that claims of public interest immunity are just that, claims which are for the Senate to accept or reject. Withholding information from the Senate because it is politically embarrassing or of contestable legality does not accord with good governance and prevents the Senate from fulfilling its scrutiny and accountability functions. These are functions which are vitally important for the democratic process. When serious actions are being undertaken in the name of the Australian people have a right to know what they are, why they're being taken and whether they indeed are necessary. And this is not a principle which should be abused. More broadly, the committee found that the Senate's current procedures for obtaining documents subject to a disputed claim of public interest immunity and for resolving these disputed claims are inadequate. By contrast, the committee heard in detail about the procedures of the New South Wales Legislative Council, where an independent arbiter is able to consider and provide advice on disputed claims of public interest immunity. In that case, an independent person has the ability to scrutinise the documents and form a view, as opposed to a situation where those who are not willing to have the documents disclosed merely assert that they are subject to public interest immunity. The committee, therefore, the Legal and Constitutional References Committee, has recommended that the Procedure Committee examine this matter in greater detail. Specifically, the Procedure Committee should consider the New South Wales Legislative Council's model of independent arbitration and how such a process might be applied in the Senate, so that the Senate does not continue to be frustrated by disputed claims of public interest immunity into the future, thereby frustrating the Senate's ability to carry out one of its most fundamental functions in a democratic society, and that is making sure that there is proper scrutiny and accountability of executive government on behalf of those people who voted us in. I'd like to give my thanks to the hard work of the committee secretary and the staff of the Secretariat in conducting the inquiry and providing the reports, and particularly to those witnesses who gave the generosity of their expertise and time. This was of great assistance to the considerations of the committee. I think particular thanks are due to the Clerk of the Senate, Dr Rosemary Lang, and the Clerk of the New South Wales Legislative Council, Mr David Blunt. I commend the report to the Senate.